Hi there, and welcome to our next 10-minute talk in which we're going to be talking about NDAs and how they impact and what the issues are in particular for partnerships and firms. I'm Beth Hale. I'm a partner and our general counsel at CMRE, and I'm delighted to be joined for, I think, her first 10-minute talk appearance by Corinne Staves, who's one of our partners. So why are we here and why are we talking about NDAs? And for those of you who follow this series of 10-minute talks, you may remember that approximately a year ago, we did a talk on NDAs, a 10-minute talk on NDAs, and talked about the issues and the key considerations for employers and for senior executives entering into them. What we're going to be doing today is talking about, as I say, the particular issues for firms and for partnerships in relation to NDAs. And I think the key thing to remember is that NDAs haven't gone away as an issue.
When we're talking about NDAs in a partnership context, it sort of feels like it doesn't fit. You hear about non-disclosure agreements in the context of employees and sort of silencing employees and those sorts of things that hit the headlines. When you're thinking about a professional services firm, for example, or a financial services firm, it's hard to see necessarily how that sort of slots in. But actually, it is incredibly common to find a confidentiality clause in a settlement or a retirement agreement at the end of a person's time as a partner, sometimes on an admission document, but most commonly in some kind of retirement deed. And actually a confidentiality provision is effectively a non-disclosure obligation in the same way. So we need to think about those. And as we'll discover in a minute, we're going to come on also to the extent to which confidentiality agreements in capital transactions like mergers or listings, the extent to which they could be considered non-disclosure agreements and therefore something about which we have to be quite mindful.
So I think it's, just really important to remember the issues haven't gone away. It's something that people are still talking about an awful lot. And a light has well and truly been shone on how NDAs are drafted. And as you rightly say, confidentiality provisions within settlement agreements, exit agreements, retirement deeds are NDAs for those purposes. So anyone seeking to obfuscate and say it's a confidentiality provision, not an NDA, doesn't work. They're basically the same thing. In terms of sort of what the issues are and what we should be focusing on, who in a law firm or a partnership ought to be thinking about these issues?
Great question. Well, obviously the person that is being subjected to the confidentiality clause is going to be incredibly focused on it, or they should be. But I think in practice, it's going to be the firm's GC in the largest firms. It's going to be the managing partner, perhaps in the smaller firms that manage partner exits. If there's a partnership secretary team, they're going to be sort of concentrated on it. Fundamentally, it's those people who are putting together the documents relating to the partner's retirements. And so it could be anyone, frankly, but the really key aspect there is those people that are regulated by the SRA. They need to be very mindful about what they're drafting. But I've sort of jumped ahead a bit there, Beth. I think that we were hoping to hear from you about what these people should be bearing in mind when they are drafting confidentiality provisions for these documents.
Absolutely, and I think you rightly refer to the regulatory regime, and that in particular the SRA Warning Notice from March 2018, which has subsequently been updated, which basically sets out the parameters in which lawyers can draft NDAs and the issues they ought to be thinking about. And that applies to people, lawyers, employment lawyers and partnership lawyers drafting them to put into settlement agreements, but it also applies to law firms who are entering into settlement agreements, NDAs, with their departing partners, joining partners, whoever it may be, and their employees. So it's got a pretty wide scope. Any regulated person has to bear that warning notice very tightly in mind. And I'm not going to go into detail about what that warning notice says, but the key things that it sets out are that an NDA must be absolutely clear about what is prevented, what is protected, and what is prevented. What confidential information are you trying to protect? And what disclosure are you protecting against? And most importantly, actually, you have to make very clear, you ought to be making very clear what you are not, what the individual entering into the NDA is not prevented from doing. So you should included in an NDA should be a list of carve-outs to say, amongst other things, that doesn't prevent someone from blowing the whistle under the whistleblowing legislation, doesn't prevent someone from talking to their family, to a therapist, to a legal advisor, to a medical advisor, to other specialist advice. And it doesn't prevent people from speaking to law enforcement, doesn't prevent people from speaking to the police, and really importantly, obviously, doesn't prevent people from speaking to the regulator, whether that is because they've been approached by the regulator themselves or because they just want to go and make a disclosure, make a report to the regulator. So it's really important that NDAs should include all of those carve-outs to make absolutely clear and make sure that everybody signing an NDA knows what they're signing, knows what they're committing to, and really importantly, what they're not committing to.
See, I think that's really interesting, because so often when you see a retirement deed in a sort of professional services context, for example, the confidentiality provision is sort of a boilerplate clause where it's just sort of towards the end of the document, you've talked about the money, you've talked about the restrictive covenants, and when everything's going to be paid, what you can and can't do, which staff you can and can't take. And then you get to the end and then there's a confidentiality provision, and everyone just sort of almost sort of skips past it. Which I think is very dangerous, because as you just quite rightly pointed out, there's a lot of sort of potential bear traps for regulated people producing these. And I think the other really interesting aspect there is that the only time that we ever do discuss it is when we're standing there going, well, should we have this confidentiality provision which we find in this retirement deed, or there's actually a confidentiality provision in the LLP deed, as it usually is, already. How do the two interact is the question that comes up. Do we need it? And I suppose my question to you, Beth, is should we even have a confidentiality provision at all if we've already got a default confidentiality provision under the LLP deed?
Well, I think that's a really good question. I think the question to which everyone's minds ought to be applied when you're looking at NDAs and looking at whether there should be one in a particular retirement deed, for example, is what are you trying to protect? Yeah. Is it the confidential information of the firm, of the partnership, in which case that is probably provided for in the LLP agreement, and you can simply cross-refer to that provision. If there is other information that you're trying to protect in terms of, for example, the terms of someone's departure, how much money they're getting on departure, or indeed things which happened in the run-up to their departure, with all the caveats around what you can't protect, then you may well want a new an additional confidentiality provision NDA in that retirement deed. But I think including it as a boilerplate is very dangerous, as you say. I think you really need to think about, what are we trying to protect, and why are we trying to protect it, and do we actually need to protect it? What are we gaining from this confidentiality provision, rather than that sort of knee-jerk just include it because that's what we do and that's what we've always done, and frankly that's what it says in our precedent. And I think that's where the sort of danger lies.
Yeah, I think you're absolutely right. And actually what I find fascinating in this context is so often these are discussed, but for the individual partner, sometimes they've breached the provisions. If, for example, they've spoken to a headhunter, they might have shared information that they shouldn't have shared, either from a contractual or from a regulatory perspective around who they act for, billings figures and things like that. So and sometimes there's warranties in a retirement deed too. So it's a really difficult area that is probably not helped by having further confidentiality obligations.
Yeah, absolutely. And I think if you're advising either party entering into these agreements, you need to focus on what is being protected and what they're prevented from doing. Yeah. And a departing partner needs to exactly think about, have they already breached, and are they signing a warranty which says I haven't breached before signature, and really thinking about sort of how it all ties together, including in terms of what they've done before. And I think that what you talk about, speaking to headhunters, speaking to future firms, is really important, because I think people assume there's a kind of green card there to just sort of say whatever you like because you're transferring your business, potentially transferring your practice. Well, there's not. Your confidentiality obligations still apply, and that's really important from a regulatory and a partnership perspective.
Absolutely. And actually that touches on a really useful note, actually, because we're thinking here about the confidentiality provisions as they arise in the context of departing partners, which is kind of the most common, to be perfectly honest with you. But the other circumstances is often where we see capital transactions with professional firms. A classic example is a merger. And often prior to a merger, indeed, it's a good idea prior to a merger to have some sort of terms in place around exclusivity and about confidentiality before you get sort of your formal heads or merger documentation in place. And normally there will be a provision in there about keeping any information confidential. And I think it's really important that regulated people think about what they're agreeing to there as well, because if you think about it, when you're doing a merger, you're quite often, as part of the due diligence, being exposed to a vast amount of information about the firm that either you're being acquired by or indeed that you are acquiring. The whole point of a due diligence exercise is to try and find skeletons in each other's closets so you can work out whether you're happy to sort of go ahead with the merger or not. And if a firm found something very alarming, and I'm talking about something like, financial misconduct, misuse of client accounts, something like that, or a serious regulatory breach like brushing serious sexual misconduct or something under the carpet, not making reports to the regulators, deliberately choosing not to do so as not to sort of have that risk, then I think the firm that discovers that information would have a very serious decision to make about whether or not they were obliged to report to the regulator. And actually, there was a thematic review quite recently for the SRA on immigration matters as it happens, but there were some really interesting general comments from that review from the SRA. And they've made it very clear that if a firm discovers something about another firm, and the example they gave was where a file was transferred from one file to another, but that demonstrated that another firm had breached the regulatory obligations, then that firm has an obligation to report the firm that has failed. And I think that principle applies in a due diligence scenario. So the confidentiality provision, to bring it back to the main point, has to allow for the firm that's discovered the issue to be able to report, in this case to the SRA, any regulatory breaches that it's discovered about the other firm during due diligence, which I think would probably come as quite a surprise to firms embarking on a merger.
Yeah, well, I think the point you make about firms potentially in some circumstances having to report other firms to the SRA is an uncomfortable one for a lot of lawyers. Yep. I think that's never going to be a sort of comfortable thing to do, is it? Because making any report to the SRA feels like a big deal. There's that sort of I don't want to be a snitch kind of feeling hangover from primary school. But yeah, really important. And I think obviously an NDA wouldn't actually prevent any firm from making that report. But I think in line with the warning notice, which applies to NDAs more generally, that ought to be clear in any NDA which is entered into between two firms in that kind of scenario. It should be clear that it's subject to any regulatory obligations they may have. And you might not, regulatory obligations, if they have an obligation to report, the NDA can't prevent them from doing so, and that should be clear, I think.
Yeah, I think that's right. I think that's absolutely right.
I think we're nearly done. It's been so interesting, and I think it's so important to think about, well, just to remember why we talk about NDAs, and what and why it's important, not just in the employment and particularly the sexual harassment context, which is the context in which they're often discussed, but more broadly as well, and just remembering that all of these restrictions and thinking about how to use them and how not to use them and how not to abuse them should be cuts across all areas of practice, I think, and it's so important. But I thought we might wrap up with like a top tip about what would your top tip be on NDAs and partnerships?
I think I go back to the original comment, which is confidentiality provisions are not boilerplate.
Okay, so my top tip would be, along similar lines, but really thinking about clarity of confidentiality agreements. What are you protecting? Why are you protecting it? Does everybody understand what they are signing? And if not, they should. So thanks very much for joining me, Corinne. Thanks very much to everybody for listening and watching, and we hope to see you again soon.
Thanks so much.